Good evening and welcome back to Courts Today by Live Law. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. The Supreme Court bench comprising Justices Bela M. Trivedi and Pankaj Mittal today questioned the Tamil Nadu government's standing to file a writ petition before the Madras High Court challenging summons issued by the Enforcement Directorate to the district collectors. The ED had issued the summons in connection with the alleged illegal sand mining money laundering cases. In November last year, the High Court had put a stay on the operation of the summons in the case under PMLA while allowing the investigation to continue. The court was today hearing an SLP against the same. Justice Trivedi asked the state government to demonstrate its locus standi to file the writ petition as to why the state was interested in the outcome of the matter. Senior advocate Mukul Rohtaki, appearing on behalf of Tamil Nadu, argued that there was no prohibition under the law enjoining a state from commencing this writ action. He also pointed to ED's writ petition pending before a bench led by Justice Suryakant seeking to transfer the investigation of a bribery case against its officer Ankit Tiwari from the Tamil Nadu DVAC to the CBI. He contended that the Enforcement Directorate acted without jurisdiction since none of the offences were scheduled offences under the PMLA. When the bench indicated that it would issue notice and seek the collector's response, the state of Tamil Nadu insisted on being allowed to file a response to ED's petition. Accordingly, the bench has agreed to hear the matter on Monday. In an important update, the Supreme Court today questioned whether a High Court could overturn a conviction under the POCSO Act just because there was consent in the sexual intercourse. This questioning arises because the law mandates a minimum punishment and there is no constitutional requirement for the High Court to ensure complete justice as enjoyed by the Supreme Court. A bench of Justices Abhay S. Oak and Ujjal Bhuya raised this concern while hearing a suo motu writ petition and an appeal against a Calcutta High Court ruling. If you remember, the Calcutta High Court judgment drew attention in December last year for advising adolescent girls to control their sexual urges to avoid being labelled as a loser by society, especially if they engage in brief sexual encounters. Today, the bench granted leave in the SLP filed by the West Bengal government and directed both the matters to be listed for final hearing on 2nd May. In another update, the Union Territory of Jammu and Kashmir today agreed before the Supreme Court to publish the orders passed by the review committees regarding internet shutdown in the region except for the internal deliberations. The review committee, let me tell you, constituted in terms of Rule 5 of the Temporary Suspension of Telecom Services Public Emergency or Public Safety Rules of 2017, reviews the internet shutdown orders passed by the competent authority. The bench comprising Justices B.R. Gawai, J.B. Pardiwala and Sandeep Mehta was hearing an application filed by the Foundation for Media Professionals. Appearing on behalf of the petitioner, Advocate Shahadan Farasat expressed that Jammu and Kashmir was the only region where the review orders of the committee had not been published, while all other states had published the same. While recording the stand of the Union Territory, the court clarified that the internal deliberations of the committee need not be published. It also added that reasons of the order also need not be published. The Supreme Court has asked the Union of India to inform whether it is contemplating to introduce a new bail law as per the recommendations made by the court in its 2022 judgment titled Satyendra Kumar Antil versus CBI. While this judgment, the Apex Court had advised the Union government to consider enacting a specialized legislation in the nature of Bail Act to systematize the bail granting process. Also, earlier this month, the court had sought affidavits to compliance from states and its high courts regarding the directions issued in 2022 judgment. A bench comprising Justices M.M. Sonduresh and S.V.N. Bhatti, while ascertaining the compliance of this recent order, has asked the centre about the new bail law. Union has been directed to update the court on whether there has been any assessment to determine the need for establishing additional special CBI courts in districts with a high backlog of cases, along with providing the necessary data. Additionally, the court has directed the union to appraise it of whether investigative agencies beyond the CBI under its jurisdiction are adhering to the guidelines outlined in the Satyendra Kumar Antal case to prevent unwarranted arrests. Today, a bench led by Justice B.R. Gawai expressed concerns about the possibility of conflicting orders in a matter after a bench led by the CJI passed directions with respect to zoos within the forest. This is because a bench led by Justice Gawai has earlier reserved judgment on the very same issue. So last week, a bench comprising CJI Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra directed the states and union territories to comply with the dictionary meaning of forests as laid down in the 1996 judgment in T.N. Godavarman Tirumalpad versus Union of India case till the identification of forests as per the 2023 amendments to the Forest Conservation Act is completed. The bench further ruled that any plans to establish zoos or safaris in forest areas, excluding protected areas as defined in the Wildlife Protection Act, owned by government or any authority, must receive prior approval of the Supreme Court. This interim order was issued amidst a series of writ petitions contesting the 2023 amendments to the Forest Conservation Act. ASG Aishwarya Bhati, who appeared before the CJI-led bench, was questioned by Justice Gawai today as to whether she had informed the CJI's bench about this fact. She then clarified that the CJI bench was informed about the same and that it was only an interim order passed. In a significant order, the Supreme Court has recorded a standard operating procedure to implement the scheme for support to poor prisoners. The union proposed this procedure while the court was ascertaining compliance with the directions in the landmark decision of Satyendra Kumar Antal versus CBI. In this judgment from 2022, the court had stressed importance of the rule bail over jail and had issued a slew of directions to prevent unnecessary arrest and remand. Earlier this month, the division bench of Justices M.M. Sondaresh and S.V.N. Bhatti passed certain other directions for its compliance by the states and its high courts. Besides this, the court also took into account this SOP titled Guidelines and Standard Operating Procedure for Implementation of the Scheme for Support to Poor Prisoners. The procedure as framed by the union has been reproduced in the present order to ensure its compliance. The SOP is divided into three parts. It proposes specific directions for support to poor prisoners, under trial prisoners and convicted prisoners. The Delhi High Court today dismissed a plea seeking permission to offer prayers and visit the graves on the occasion of Shab-e-Barat at the site of the recently demolished 600-year-old mosque in the city's Mehrauli area. The mosque, along with a madarsa and various graves, were demolished by the DDA on 30th January. Advocate Shams Khwaja, appearing for Managing Committee of Delhi Waqf Board, filed an application in a petition pending since 2022. It was contended that the urgency of filing the application was Shab-e-Barat. It is the occasion of forgiveness where Muslims offer prayers throughout the night in the 700-year-old mosque and visit graveyards. But Justice Purushendra Kumar Gaurav dismissed the application and observed that as of now, the site in question is in the possession of DDA and the court is already seized of the main petition, which will be heard on 7th March. And lastly, the Bar Council of India in a press release has commended the government for passing the three criminal bills, that is the Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita and the Bharatiya Sakshay Adhiniyam. BCI said the repeal and replacement of the Indian Penal Code, the Code of Criminal Procedure and the Indian Evidence Act signify a move towards transparency, technological assimilation and forensic advancements to enhance investigations and conviction rates. Further, recognizing the pivotal role of legal practitioners, the Bar Council pledged support through a structured roadmap for their training and upskilling. The roadmap outlined key focus areas, a blended learning approach, specialized training programs, and regional training centers to ensure accessibility and effectiveness. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share, and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.